I do not run a Jerry Springer show. I do not run a Jerry Springer show.
I don't feel safe, and it seemed like you were getting a little angry. I don't know. I mean,
I'm not getting angry, sir.
We've got a police officer and we've got a prosecutor. Both are state actors, and they're trying to bring charges against me. And I just want to know, because you are a judge and you are another state actor, am I going to get a fair and meaningful hearing here? Because I'm being labeled and called the defendant here. And what I'd like to be called is the victim. Outstanding, because I'd like to talk to this prosecutor who I suspect is a criminal at this time.
A recent Zoom court hearing took a chaotic turn when a self-proclaimed sovereign citizen appeared, claiming to be the victim, despite facing charges for resisting arrest and using debunked legal arguments. What followed was a confusing and at times frustrating display. As he attempted to represent himself with little more than internet-level legal knowledge, the judge remained calm at first but grew visibly frustrated as the hearing dragged on. The situation quickly escalated into a courtroom meltdown, highlighting just how unpredictable these virtual hearings can become. Zoom court has introduced some real challenges, especially with these kinds of cases. This one's a clear example of how quickly things can spiral when legal processes are ignored. Let's take a closer look at how it all unfolded.
Okay, Mr. People versus Lanto.
Your Honor, James Kazicki, I'm asking the court right now if I could withdraw on this matter. I don't think I could adequately help Mr. Lanto in his legal arguments because I'm not familiar with the issues in it. And I'm just asking the court if I can withdraw.
All right. Then, Mr. Lanto, then I can appoint a different court-appointed attorney.
Well, I just want to clarify and make sure I'm going to be able to speak for myself in the court. I don't want anybody speaking for me. As a matter of fact, I mean, all I really want is to be left alone. So that's first and foremost. And then as far as an audio-only recording, I was told that there's an objection to the audio-only recording. And I'd like to know, I don't feel safe without a recording. So is there any reasonable objection?
Well, first off, you can't record in the courts of law. They're already, if you'd like a transcript, everything is already being recorded by my court recorder. And I can assure you that there's no, the recording device is on and it records, and that's what she does. She records everything. So if you'd like a transcript of that after the proceedings, you're more than welcome to order a transcript. So
I've been told that before, and then when it comes to getting the transcripts, I still am waiting for the transcripts when I was told that in the past. So
well,
like I said, I don't feel safe without a recording.
I know that you're not talking about the 23rd District Court, because I know if you've ordered a transcript from my court, those are always forthcoming. I've never had to deny anybody a transcript. So if that happened to you in another court, then I suggest that you call the State Bar of Michigan and report that court, because obviously they're not doing things correctly.
Well, yeah, I have no desire to do that. All I want is to have fair and meaningful hearings. And well, I mean, first off, I'd simply just like to be left alone. But other than that, I mean, to get fair and
I get that, but obviously you had an interaction with somebody where they are alleging that because today's the date and time set for the arraignment. So I want to make sure that you understand. I need to file. On the date and time in question, it is alleged that, because first let me do the arraignment part, because I need to let you know what exactly you're being charged with. All right. So you say you want to be left alone, but they are claiming that there was an interaction. Now, first off, you do have the right to remain silent. Anything you say can and will be used against you. You also have the right to an attorney if you got a 411 will be appointed to you by the court at public expense. Now, it is alleged that on November the 17th of 2022, while in the city of Taylor, that you violated City Ordinance 32-31, which is a charge commonly known as interfering with the police authority. That is a misdemeanor punishable by 93 days in jail and or up to $500 in fines. So, as to that charge, how do you plead? Guilty or not guilty?
well, first, can I just make a few clarifications?
I'm going to caution you that anything you say can and will be used against you. So
I understand.
As to guilty or not guilty. That's just the only question I'm asking right now.
Well, in order to say guilty or not guilty,
Or you can stand mute, which means I'm not saying anything, and then I will enter a plea of not guilty for you, so that you don't have to say anything, and it automatically goes to not guilty. So are you pleading guilty, not guilty, or standing mute?
well, before I make a plea, you stated that I have the right to be informed of the cause and nature of the charges, correct?
The timer in the bottom left marks the moment the sovereign citizen arguments begin. Rather than entering a standard plea, the defendant starts delivering a speech about why stop signs are allegedly unconstitutional. These types of claims have become common in certain online circles, though they hold no legal weight. Arguments like this are often based on misinformation and misunderstandings of basic law. Despite repeated rulings across courts, some individuals continue to rely on these tactics, believing certain words or phrases can override established legal procedures. The following moments show just how quickly these approaches fall apart under real courtroom scrutiny.
Right, which is what I just told you. I just told you what the charge was.
Okay, and you're stating that it's based on an interaction. So my guess is that you have no firsthand knowledge of anything that happened?
Well, I'm not stating anything. All I'm telling you is what the people of the city of Taylor have charged you with. They have charged you with a violation of City Ordinance 32-31. That ordinance is commonly known as, by name, as interfering with police authority. I'm not putting any allegations. I'm not stating any facts. I'm merely stating what has happened to get this case into my courtroom. That's it.
Well, you sound awfully fair to this point, and I certainly appreciate that. Because, yeah, and just to be specific, it's not the people of the city of Taylor, it's David Jones, and then I don't know the name of the prosecutor, and I just want to make sure that the prosecutor is aware of, Section 241, Section 242, Title 18, deprivation of rights under color of law. I want to know if they're aware of that.
Well, first off, that's a separate, what you're talking about is civil type cases.
Well, it's also criminal.
So what I'm saying is, in this matter, the matter that is before me, okay, is a misdemeanor matter where it is alleged that you violated an ordinance of the city of Taylor. The people of the city of Taylor, through their attorney, have acted to bring a case against you. So the only thing I can do right now is ask you, are you pleading guilty, not guilty, or standing mute?
Can I have the name of that prosecutor that's bringing the charges? Because I've had in another case where a prosecutor stated at 3 proceedings away from the arraignment, she stated that after reviewing the video.
So, sir, I'm going to take your response as being non-responsive, which is
well, I object to that.
Do with being guilty or not guilty. So I'm going to enter a plea of not guilty for you.
I object to that. I object to that.
Okay, then are you guilty or not guilty? Or standing mute? Those are the 3 things we got going on right now.
Well, I first have to clarify. You did say that I was presuming.
I don't have to clarify anything, sir. I'm being very fair with you. And right now, you're basically splitting legal hairs. Right now, the only thing that I have jurisdiction over is doing arraignment. Nothing more can happen in this case until the arraignment happens. And the arraignment is whether or not you plead guilty or not guilty. And if you're unresponsive to that question, then I'm going to enter a plea of not guilty for you so that I can protect your constitutional rights, because a lot of people don't know that they should. So that's why I enter a plea of not guilty for people who don't really know how to answer the question. So that way they're not getting, no one's going to be bamboozled or said that, well, you said guilty and you didn't know what was going on. I don't want that to happen. I say that you're either going to plead guilty, not guilty. If someone is unresponsive to that question, then I automatically just enter a plea of not guilty for them so that they can preserve all of their rights to a trial and everything else without having been forced to be pleading guilty. So by you saying everything else, that's all well and good, but it's not the time and place for it. See, that's the problem is there's a time and place for everything in the matter of procedures of courts. And when you just start trying to jump the gun and go right from 0 to 60, that's not how it works. There's a stepping process and everything has to go in that process. And the process today is an arraignment. It's just an arraignment where I'm telling the individual who is alleged to be a defendant what the allegations are. And the allegation is that you violated a city ordinance, and that city ordinance is basically one commonly known as interfering with the police authority. So that's and letting you know what the charge is. and letting you know what the penalty for it is. And I've
Well,
already
yeah.
stated. So again, I'm going to ask you, guilty or not guilty?
Well, I certainly appreciate the explanation. It seemed like you were getting a little angry. I don't know. I mean,
I'm not getting angry, sir.
This incident reflects growing concerns around virtual court hearings. When individuals using sovereign citizen arguments appear via Zoom, the format often gives them more room to disrupt the process. In this case, the participant challenged the entire legal system while also facing basic technical issues, which made the hearing difficult to manage. There also appeared to be an effort to provoke the judge, potentially to later claim judicial bias. Cases like this are further complicated by legal standards requiring judges to step aside if they're perceived as too emotionally involved, even when dealing with clear disruptions, while virtual courtrooms were introduced to increase efficiency and access. They've also introduced new challenges in maintaining courtroom order and decorum. These moments continue to raise important questions about how remote hearings are conducted and moderated.
But I'm literally stating that nobody's trying to bamboozle you or anything like that. I don't know what happened in some other court, and everything that you want to do, you can still do. I just need to know if you're pleading guilty or not guilty. And if you're not answering that question, then I'll enter a plea of not guilty for you so that it preserves all of your constitutional rights and the case still moves forward.
Right. You said we're interested in preserving my constitutional rights, correct?
That is correct. That is correct.
And then one of those.
What I'm saying is everything that you're saying can be used against you. If you think that you have a motion to dismiss, that's something that you can do, but that's when the case is already going to the next stage, which is,
well, like I said,
of not guilty for you.
Well, like I said, I would just prefer to be left alone and not have to come back at all. And then if we're not going to do that, then I definitely like to have fair and meaningful hearings. And my concern is we've got a police officer and we've got a prosecutor, both are state actors, and they're trying to bring charges against me. And I just want to know, because you are a judge and you are another state actor, am I going to get a fair and meaningful hearing here? And
I'm telling you that I keep right here. Hang on 1 second. Copy of my, sir, please. I have not cut you off at any point. Please don't cut me off. This is a copy of my oath of office. And why do I keep it here? Because it constantly reminds me that what am I going to do? I do solemnly swear that I will support the Constitution of the United States and the Constitution of this state, and that I will faithfully discharge the duties of the office. So I take that very seriously. My son serves in the Marines. He takes his duty to uphold the Constitution seriously. So if you are implying that I am not going to uphold the Constitution, or that I am going to take an oath and not be true to my oath, then I take offense to it. So if you sense any sort of anger, there's no anger. The only thing I'm telling you is that you are implying that I somehow am an oath breaker, and I am not. Well,
I didn't. I didn't.
That's exactly what. I swore an oath to the Constitution that I put my hand on the Bible and swore to, and I'm telling you, I don't break my oath.
Okay,
so
would you agree
that implying that you're not going to get a fair hearing? That's my job, is to make sure that fairness happens, that due process happens. And so so I'm asking you, just as a matter of course, because this is the stage that we're at, is an arraignment. Are you pleading guilty or not guilty?
Well, you just said.
Or if you're not responding to that question, I'm going to enter a plea of not guilty on your behalf, and I'll find you standing mute to the question.
Well, I object to anybody making a plea on my behalf, and I just wanted.
I'm not making a plea.
Well, at this point in the hearing, the defendant declines to make a standard plea and instead begins repeating common sovereign citizen arguments, claims that have been consistently rejected by courts as having no legal merit. It remains unclear whether these statements are made out of genuine belief or as an attempt to find a loophole. Either way, the arguments are often rooted in misinformation and have no basis in actual law. The judge maintains professionalism throughout, despite frequent interruptions and irrelevant legal references. In cases like United States versus Mitchell, the courts have clearly stated that such arguments are utterly frivolous. These kinds of courtroom disruptions not only delay proceedings but also place additional pressure on judges to remain composed while ensuring the legal process continues fairly and efficiently.
I'm just finding you, I'm just entering, I'm just saying that that you are right now presumed not to be guilty, because that's just your constitutional right to be
Okay.
presumed not guilty.
And then
I am
that means
exercising
that,
your constitutional right. I'm not entering a plea for you. I'm just listing you as somebody who is right now not guilty. Because the Constitution says you are to be presumed not guilty until proven guilty beyond a reasonable doubt. So I'm not
And then-
entering a plea for you. I am just merely stating that this individual is to be treated as someone who is not guilty.
okay, and then, so if I'm presumed innocent, I'm presumed innocent of all the elements of the charge, correct?
No, you are presumed innocent until proven guilty. And you haven't had
Right,
a trial yet. That's your other constitutional right. So if you'd
Well,
like to
yeah,
set this for a trial, we can set this for a trial.
well, we just said that I'm presumed innocent until proven guilty, and then my question was, am I presumed innocent of all the elements of the charge? And I didn't get an answer to that, because that's a yes or no.
Well, first off, I don't need to answer questions, and nor am I going to give legal advice, because that would be more legal advice that you would talk about with your attorney. And when I'm wearing the robes, I can't give legal advice to either side. I'm more like a referee. I can throw a penalty flag, I can call a whistle for a violation of a rule that I see one side doing or the other side doing, but I can't coach either team.
Well, I certainly
So that-
appreciate you being fair. Yeah, because
So the answer to your question is I can't answer your question, because that would then be giving you legal advice, and I'm not allowed to give either side legal advice.
okay, because in this particular case, there are crimes that occurred, but the crimes that occurred were the people that put their hands on somebody that had no desire to be having somebody put their hands on them, and then binding them, and then placing them in the back of a gang mobile, and then taking them to a cage. That's the victim in this case. And the victim,
Okay,
if the victim is going to be the city of Taylor, and it's going to be presided over by a judge that is paid by the city of Taylor, with a police officer that's bringing the charges with the help of an attorney, and then they don't know what 241 or section 241 title 18 conspiracy to violate my rights, then I have serious concerns for the fairness and the meaningfulness of these proceedings. I think
Okay,
that's
well,
very reasonable.
I am a judge of the 23rd District Court of the state of Michigan. It's located in the city of Taylor, but I don't work for the city of Taylor.
But do you see do you see my concern for my safety?
No, I absolutely, except for the fact is I'm presiding over the whole case, and I'm going to make sure everybody has due process. Everybody has the same fairness to bring their case, and to make sure that they can cross-examine witnesses and make sure everything is recorded by my recorder, who also has sworn an oath, and I find her to have never have broken her oath either. And so I'm just telling you, I'm going to be doing my job, and my job is to defend the Constitution, and I will be doing so. So as of today, it was set for arraignment. I have entered a not guilty as to the charges against you. And right now I can do one of two things. One, I can set this up for a pretrial. The pretrial is something that I always afford the parties, where they can talk to one another. If they want to work something out, I have no problem with the constitutional right to enter into contracts and to do things like that. Or I can just set it for jury trial or bench trial right now. If you want to forego any of that and say, look, I really have nothing to discuss with them, I'll just like to go to trial. So would you like to meet with the prosecutor? Well, in which case I will set this up for a settlement conference date where the two of you can discuss the matter. Or I can just set this for a jury trial or bench trial right now.
Well, I mean, I do have a couple objections to that, because I'm being labeled and called the defendant here. And what I'd like to be called is the victim.
At this point in the hearing, the defendant refuses to enter a standard plea and instead relies on familiar sovereign citizen claims, arguments that have been consistently rejected by courts as having no legal basis, whether these statements stem from genuine belief or are intended to exploit a perceived loophole remains unclear. Regardless, such arguments are rooted in misinformation and do not align with established legal standards. Throughout the hearing, the judge maintains composure despite repeated interruptions and irrelevant legal references. In United States v. Mitchell, courts clearly classified these types of arguments as utterly frivolous. Disruptions like this not only delay proceedings but also place added pressure on the court to balance due process with maintaining order and efficiency in the courtroom.
And what I'd like to do is, if this is a fair... If this is a fair proceeding, then that prosecutor, as long as we're going around and throwing out suspicions and alleging crimes, I'm going to allege them of the crime of the Department of Justice, Section 241, 242, Title 18, which is deprivation of rights under color of law. And I take serious issue with people acting like criminals.
Okay, so what I'm saying is this. One, I don't have jurisdiction to take your case. Two, you're citing to federal law. Three, you would have to file that in the federal court. And, and all of those things are available to you. You have the right to do so and have the proper court, determine that. All right. So what I'm saying is this is a city ordinance, and I have jurisdiction over state cases and over city cases, misdemeanors. And I don't have, and what you're stating, I don't have the jurisdiction to hear. That doesn't mean that you can't bring that case in the proper court. All I'm saying is from now on, I'm just going to refer to you as Mr. Lanto. If you prefer not to be referred to as the defendant, then I'll refer to you as Mr. Lanto. The prosecutor is Mr. Dave Greco, and I'll refer to him as Mr. Greco. And that way, everyone will just refer to one another and their generally names. But what I'm asking you right now is, would you like me to set this for a settlement conference at a later date? Or would you like to set this for a bench or jury trial?
Well, I'm willing to forego any intention of criminal charges against the prosecutor if they're willing to just dismiss this now and leave me alone.
So here's the thing: is I'm going to give everybody the opportunity to look at the case and think about it, and not have to. I made sure that you didn't have to take a guilty plea right off the cuff without having to think about it. So I'll set this for a settlement conference. And everyone can come back at that settlement conference. And if there's if there's a resolution, then there's a resolution. If there's not a resolution, then I'll ask if you want a bench trial or jury trial, because that's your constitutional right, and I just need to know which one you're choosing. So, all right.
Outstanding, because I'd like to talk to this prosecutor who I suspect is a criminal at this time, and I would like to.
First off, I'm going to caution you, Mr. Lanto. I'm going to caution you, and I'm going to caution you once. And the next time it happens, I will hold you in contempt, because I will hold anybody in contempt. I do not run a Jerry Springer show. I do not run a Jerry Springer show where the litigants are going to use words and things and call each other names. If you're going to refer, I'm not referring to you as a defendant. I rightfully could. Anybody who has charges brought against them is for a moment known as a defendant. If you look at a dictionary and look up defendant, that's what it says. But you prefer not to be called a defendant, and I acknowledge that, and I'm going to call you Mr. Lanto. You are not.
Sure. Thank you.
You are not, and I repeat, not until you prove otherwise in a court of law beyond a reasonable doubt. You are not to call any other litigant a criminal.
Sure. Well, I've been alleged to be a criminal.
So while I will make sure that the proper respect is given to you, I'm going to ask the same of you. So you will refer to Mr. Greco as either Mr. Greco or as the prosecutor, but you're not going to call any other litigant or any other witness or anybody else a criminal unless they actually have a criminal record or they have been proven to be a criminal in a court of law by a jury of their peers.
Yeah, and for the record, I called him a suspected criminal.
The defendant enters the courtroom and begins using scattered legal terminology, often associated with conspiracy-based arguments. Despite multiple instructions from the judge, there is a continued refusal to follow standard procedure. The individual appears confident, even while presenting claims that hold no legal weight. This pattern reflects a recurring issue where defendants believe they can bypass legal processes through unsupported theories. Or efforts to take control of the proceedings are ineffective and frequently result in delays or additional complications. As the hearing moves forward, the key question becomes whether a proper plea will be entered or if the attempt to avoid formal procedure will continue to.
I'm very careful with my words.
Again, you're splitting hairs, and I'm just telling you right now, I'm giving you one heads up. And I don't allow any kind of Jerry type Jerry Springer stuff where there's going to be finger pointing, chair throwing, and name calling.
Well, I did do a cop watch karaoke, which is probably what led up to this.
All right, so I'm going to set this for a settlement conference. All of your contact information is correct, so I can make sure that due process is afforded under the Constitution, and I'm mailing notices out to the proper spot, and that's the Cloverdale address.
No, and at this time, I don't feel safe giving an address, but I'll give you a phone number or an email address that I can be contacted by because I do want to participate in the settlement conference.
Well, right, but I also need to, I'm required by law to mail it out to your last known address. So if this address is something that you will still receive, all I'm saying is I already have an address. I don't.
Yeah,
I'm
no,
just saying, is it still current? Is it still
in the
current?
in the activism that I do, it's important to stay on the move because I have people that try to retaliate against me and do violent things to me. So I prefer not
Well,
to.
then that's up to you. That's up to you to go to the, it is incumbent upon you to go to the post office and make sure that they have your forwarding address. I'm gonna mail, my clerk is gonna mail it out to the Cloverdale address. And if you didn't put a forwarding on there, well, that's between you and the post office. We
Well,
don't
if they
send out
don't,
emails. We don't send out emails as notice, and we don't make phone calls about to let people know when the notice is. We use the mail system because that's the only thing that's tangible and can actually be proven. Why? Because you can see that you put something in the mail. You can actually see that it's been in the mail because it's posted. So
yeah, is it going to be certified? Because that's the only way really to prove that somebody got it.
no, it's not, and we don't have to send it by certified mail under the court rule. And the court rule has already been ruled to be part of the Constitution, and it's already been ruled as being constitutionally proper under due process of the Constitution. So I'm going to mail it to your last known address. If you have some sort of change of address, that's between you and the Postal Service. All right. So we're going to set this for a separate conference date. It'll be sometime in the new year, sometime in January, and we'll see everybody then.
Okay, I certainly appreciate you being fair.
That's what I swore to do. That's what I always do. Have a good day.
Thank you.
An update on the case may be available at a later time. However, given the defendant's decision to accuse the prosecutor of criminal behavior during the hearing, a dismissal appears unlikely. Individuals making sovereign citizen claims often cite ideals like liberty and justice, but frequently resist even minor legal obligations, such as paying routine fines. While not the most disruptive case of its kind, the behavior in this hearing added significant delays and challenges. Some observers may question whether the judge exercised enough authority in response to the repeated interruptions. In United States v. Benner, courts have clearly stated that sovereign citizen arguments are completely without merit and patently frivolous. Despite established precedent, such claims continue to appear, particularly in virtual hearings where courtroom control is more difficult to maintain. Remote court sessions, especially those involving these types of arguments, continue to raise concerns about decorum, credibility, and the overall effectiveness of legal proceedings in a digital setting.